Mrs. Holness, Mr. Bartlett, Mr. Holness, Dr. Clark, Dr. Chang, Mr. Shaw, Mr. Samuda, Ms. Grange, Mrs. Williams, Mrs. Malahoo Forte, Dr. Tufton, Mr. McKenzie, Mr. Chuck, Mr. Vaz, Mr. Warmington, Mr. Charles, Mr. Green, Mr. Morgan, Mr. Hutchinson, Mr. Terry Long, Ms. Smith, Dr. Dunn, Mrs. Cuthbert Flynn, Mr. Mean, Mr. Davis, Mr. Witter, Mr. Brown, Dr. Brown Burke, Dr. Charles, Mr. Chin, Mr. Clark, Mr. Cousins, Ms. Crawford, Ms. Daly, Ms. Davis, Mr. Golding, Mr. Graham, Dr. Guy, Ms. Hamilton, Ms. Hannah, Mr. Henriquez, Mr. Henry, Mr. Hilton, Mr. Jackson, Mr. Lawrence, Ms. Lee, Mr. Miller, Mr. Montague, Ms. Morrison, Mrs. Nita Garvey, Mr. Paulwell, Mr. Phillips, Dr. Phillips, Mr. Robertson, Mr. Robinson, Mr. Siblist, Mr. Slowly, Mrs. Vaz, Dr. Wheatley, Mr. Williams, Mr. Wilson, Mr. Wright, Mr. Williams, Dr. Chang, Mr. Charles.
Members, I want to welcome all parliamentarians to the sitting of the House this afternoon. I also want to extend a very special welcome this evening to those who are joining us in the gallery. And I gather this evening we have students from the UWI, University of the West Indies, Faculty of Law. We welcome you heartily. And of course, I welcome those joining us online by the various social media platforms. This is not indeed the first sitting of the House, but for 2023, but it is my first sitting since the clerk to the Houses and myself were away attending a Commonwealth Parliament conference when we had the first sitting. I therefore want to wish and to thank all our parliamentarians on both sides of the aisle for the cooperation I had from you all in the past year, 2022, and look forward to that continued support and cooperation for the year 2023. I want to also thank the clerk and her staff to the Houses of Parliament for their guidance and their support, and I am looking forward to a productive and harmonious 2023. And I have chosen the two adjectives very well. Let us also be reminded that members that this House is a people's House. It's a people's parliament. We are their representatives, and therefore we should at all times do so at the very highest possible standard. I want to just, on a sad note, and on behalf of us all as parliamentarians, to take note of the passing of the dear wife of one of our member from Northeast St. Elizabeth, and to ask God to be with him and his family during this difficult period, and particularly as he seeks to serve his constituents. It's a difficult time, and we ask for God's guidance as he moves forward with his family, and particularly his children as well. House Leader? Statements by ministers, and I pass it over to the House Leader.
Thank you, Madam Speaker. At this time, we will have two statements, one by the Honorable Delroy Chuck, Minister of Justice, followed by the Honorable Marlene Malahoo Forte, Minister of Legal and Constitutional Affairs. Thank you, Madam Speaker.
I take it you have circulated copies of your presentation. Is the opposition in receipt of...
Madam Speaker, I have provided a dozen copies so that it should be sufficient. I hope you have a copy, Madam Speaker.
I do.
And other members could get copies. Permission to speak from a seat other than my own, Madam Speaker. To be frank with you, I'm not too sure where I sit, but...
Permission is granted. Go right ahead, Minister.
Madam Speaker, the government and the public at large are extremely concerned about the levels of murder across the island. Jamaica has consistently had the second highest murder rate in the world since year 2005, recording 1,498 murders island-wide during calendar year 2022, which represents a 2% increase over the corresponding period in 2021, where the number of recorded homicides was 1,474. Of this number, there are numerous instances of multiple killings occurring in any one event. We had an average of 4 persons being killed per day in 2022. The Offences Against a Person Act, the OAPA, provides for the offences of murder and the associated penalties, also provides for the division of murder into 2 categories, capital and not capital. It stipulates as follows, Madam Speaker. In section 3(1)A, the penalty for capital murder is death or life imprisonment, and in section 3(1)C, subsection A, states that where life imprisonment is imposed, a minimum period of 20 years must be served before parole can be considered. In section 3(1)B, for non-capital murder, the applicable penalty is life imprisonment or a fixed term of not less than 15 years. Section 3(1)C provides a corresponding minimum period of 15 years and 10 years respectively that must be served before parole can be considered. Madam Speaker, given the promulgation of the recently passed Firearms Prohibition, Restriction and Regulation Act 2022, which stipulates a range of 15 to 20 years mandatory minimum for various firearm-related offences, there is an urgent need for the alignment of the minimum mandatory penalty prescribed in the OAPA for the ultimate crime of murder. Parliament should note, Madam Speaker, that an assessment of the applicable penalties for other serious offences is in train to ensure rationality and consistency of penalties. The Minister of Finance, in fact, Madam Speaker, has intimated that significant penalties will be imposed for financial crimes. Madam Speaker, the key purposes of sentencing is evident within the Jamaican context are deterrence, rehabilitation, denunciation, incapacitation, and restoration. The imposition of mandatory minimum sentences via legislation is generally intended to send a strong signal that the society will not tolerate certain forms of criminal behavior. This viewpoint is bolstered by that famous judge, Lord Denning, Madam Speaker, who stated, punishment, quote, punishment is the way in which society expresses its denunciation of wrongdoing. And in order to maintain respect for the law, it is essential that the punishment inflicted for grave crimes should adequately reflect the revulsion felt by the majority of citizens for them. It is a mistake to consider the objects of punishment as being deterrent or reformative or preventative and nothing else. The truth is that some crimes are so outrageous that society insists on adequate punishment because the wrongdoer deserves it irrespective of whether it is a deterrent or not, unquote. Madam Speaker, there's an increasing clamor from victims and interested parties in support of the imposition of harsher penalties, many of whom have openly expressed that justice was not served for them or their relatives who were victims of violence. There is therefore, Madam Speaker, a need for enhanced alignment between the sentencing regimes governing serious crimes in Jamaica and the expectations of the public of the outcomes from the justice system. The preservation of the credibility of the justice system in the eyes of individuals traumatized by the untimely death of family members, co-workers, friends, or neighbors can be achieved through the imposition of a sufficiently punitive sentence. Madam Speaker, the imposition of a minimum mandatory sentence of imprisonment for murder exists in other jurisdictions, such as South Africa, Canada, the United Kingdom, and certain states in the United States of America. These mandatory minimum prison sentences, Madam Speaker, range from a low of 15 years to a high of 30 years. Though consideration was given to the approach taken in other jurisdictions regarding the treatment of similar offenses, in the Jamaican context and the Jamaica's peculiar reality, namely an uncontrolled and abated murder rate, different considerations should be considered. The reputational damage resulting from its abnormality, high rates of intentional homicides, and by extension the impact on the country's GDP, the debilitating strain placed on the Jamaican populace from the daily loss of life by violent means necessitated that the penalties imposed be especially punitive. It is noted, Madam Speaker, that Jamaica has the highest homicide rate among 22 Latin American and Caribbean countries and has been characterized as the second most dangerous country in the world with a homicide rate of 43.85% per 100,000 residents on the island. Madam Speaker, the extreme situation in Jamaica warrants a deviation from the conventional sentences imposed in other jurisdictions to go beyond the average mandatory minimum sentences. An increase in the mandatory minimum sentence, as well as amendments to the section of the Act treating with the possibility of parole, that is Section 3(1)(c), Madam Speaker, for murder, are seen as legislative strategies to treat with the soaring crime rate negatively impacting the country, whilst ensuring that the applicable penalty matches the severity of the crime. In this regard, Madam Speaker, the government is proposing to amend the OAPA as follows. In Section 3(1)(b) of the OAPA, Offences Against the Person Act, to increase the mandatory minimum sentence of imprisonment from 15 years to 45 years. In Section 3(1)(c), regarding eligibility for parole for capital murder, Section 1(c)(a), increase the mandatory minimum sentence to be served before being eligible for parole from 20 years to 50 years. For non-capital murder, Madam Speaker, where the sentence given was life imprisonment, increase the mandatory minimum sentence to be served before being eligible for parole from 15 years to 40 years. And where the sentence given was a term of years, increase the mandatory minimum sentence to be served before being eligible for parole from 10 years to 35 years. The government, Madam Speaker, is firmly of the view that these proposals achieve the objective of ensuring that the potential sentence matches the seriousness and gravity of the offence, whilst remaining within the realm of constitutionality by preserving some degree of discretion in the courts and allowing the possibility of a subsequent reconsideration of the court's position. It ensures, Madam Speaker, that in the reasonable and deserving cases, the circumstances of one case could be reconsidered to determine the appropriateness of continued incarceration. In very short term, Madam Speaker, a bill will be laid in the House reflecting the government's position on the appropriate penalties to be applied to the offence of murder. Madam Speaker, a clear and unmistakable message must be sent to potential killers that their wanton and heartless act will be met with disgust, repugnance, and a lengthy period of incarceration. Having taken a life, Madam Speaker, the offender cannot and should not be allowed to enjoy the remainder or most of the remainder of his life freely and unburdened. Madam Speaker, we invite comments from everyone to indicate their position and the appropriateness of these proposed penalties, and we do invite public discussion before they're enacted. Thank you, Madam Speaker.
Thank you. Thank you very much, Madam Speaker. Madam Speaker, just before commenting specifically on the Minister's statements, I'd also, on behalf of the opposition, extend our own sympathies to the member from Northeast St. Elizabeth on the passing of his wife. And we will be praying for you and trust that God will guide you. And I was about to say shower more blessings on you, but I have to be careful. Madam Speaker, I also would like to extend welcome to the students from the Faculty of Law. And I want to do so, and the chairman of the Bail Act Committee will know why, because recently we were blessed by a presentation from the Faculty of Law, which for me was quite refreshing. It was helpful in our contemplation, as we are now doing with the proposed Bail Act. And I really believe that we have to encourage the faculty to be more in touch with us. So I'm very happy to see the students here, and looking forward to some of them replacing us in due course. Madam Speaker, I want to thank the Minister for the statement, which is highlighting, again, another major problem that we face as a country, the problem of crime and violence, and the issue in particular of murder. And we on this side share the revulsion, the antipathy, the disgust, especially as last year we saw another rise in the level of murder in our country. And we pledge to do all that we can in support of getting those numbers down. We can't be proud to be a civilized society with the level, with the reputation that we now have as one of the leading countries in relation to homicides. It is not an easy problem, and I'm so happy that we are now grappling with another dimension in the committee, the Joint Select Committee, dealing with the Bail Act. And I had reason last week to make the point, because yes, we want to appear tough. We want to ensure that the penalties fit the crime. But, Madam Speaker, for me and for us, the greater emphasis, firstly, must be to catch the criminals. We must catch the criminals. And I really want to see us focus a lot more on catching them, because bail and sentences and penalties will only arise after you catch them. And I believe that there really ought to be a lot more resources placed in detecting, in investigating, in the use of the various tools that are now available in modern societies, the use of technology and so on, to catch, to have sufficient evidence. Because as was pointed out last week, one of the problems we face as a society is a level of fear. And you do have people who will see, but will not want to talk. And our Evidence Act now allows for other types of evidence that would be far more useful than a reliance on the human factor, as we have become. You know, I've been watching this show on TV about drug trafficking and so on. And I'm amazed at the ability of dogs to not only track down drugs, but to track down guns. And the police have said to me that they don't have enough dogs to assist them, and that we continue to rely too much on the human element. I mean, sometimes I can't understand. You hear a barrage of gun firing, and there's a curfew, and the place locked down for hours, and not one gun can be found. No ammunition can be found. So we have to find ways and means, Madam Speaker, to be able to catch these culprits, people who are terrorizing our communities, people who are involved in murders. The Minister mentioned in his closing an aspect that we ourselves want to explore, and I'm hoping that this will be subject to another Joint Select Committee, because we over this side, we are preoccupied with the constitutionality of the various processes and measures that we put in place. And in your statement, you have affirmed that the government is going to make sure that the discretion that is now available to the courts, that discretion is preserved as we try to impose stiffer penalties. And we are very careful that we do not do anything, we do not pass any legislation from here that would run the risk of successful challenge for their constitutionality. So if the Minister will state what will be the process to encourage the debate, the discussion. We have had during the Bail Act sittings very good detailed discussions, provoking the public's interest, getting their views. And that might be, you looked at me with exasperation when I mentioned the Joint Select Committee. That I think is probably the best route to go, to get a sense from the public how they feel and to get their buy-in at a very early stage, and also to get the professionals who might be able to assist us with the enactment of this legislation. The person who speaks on our behalf on these matters has joined us, and I will reserve my further minute and a half, just in case that he wishes to have some concluding words.
Let me respond to just that point. The member from Eastern Kingston. I'm going to ask the Minister of National Security to respond to the question about what is being done to ensure for the penalties to be imposed, they have to catch the criminals. So the Minister of National Security will respond to that. When the bill comes, and the bill will come very shortly, which really is a the bill will be really an adjustment to the OAPA 2005, increasing the penalties and also the time to be served before parole is granted, and also an adjustment to Section 42F. The starting point is now 30 years. We might increase it to 40 or 45 years before the reduction comes. And it will also deal with children and probably provision for plea bargaining in appropriate cases. We'll work on that. Position though, Madam Speaker, as the member and we have pointed out, we're being overwhelmed by heartless criminals. So the question, Madam Speaker, yes, we must catch them, but when you catch them, you must impose severe penalties. And Madam Speaker, there's a provision known as misprison, where persons who know about these killers turn a blind eye to these killers. We intend, Madam Speaker, in the overall adjustment of penalties, if we can demonstrate that persons in communities are aware of the killers, and it can be so demonstrated, then those persons may well be charged with misprison. That's a crime. You know that person, and I say, Madam Speaker, without fear of contradiction, that far too many communities are really protecting the killers and the violent producers. And it is about time, Madam Speaker, that communities recognize that in protecting the killers and believing that they are Robin Hood, they are really engaging in a suicide pact. Because in protecting the criminals, they certainly, in my view, are encouraging people to attack that community, which is exactly what is happening across Jamaica. Community members must now appreciate that when they see guns, persons in extortion, scamming, and contract killing, these persons are setting up the community for retaliation. It's a fact of life. And it is important that community members be bold enough to use the appropriate channels, not to endanger their lives, but to use the appropriate channels to get rid of these gunmen, these scammers, these criminals, and these killers. So, Madam Speaker, the truth of the matter is that it is not the government or the opposition or parliament alone or the police. Communities must take responsibility to assist in apprehending these criminals so the punishment can be imposed. So we are putting in place the appropriate punishment where when we catch them, then those persons who inform or bring them to justice don't feel that their gallant act was in vain. So, Madam Speaker, that's my response, and I'll ask the Minister of National Security to say in response to you. Okay. All right.
Just a moment. I had recognized the member from Northwest St. James, and the deputy. You're waving. Is not? Very well. Also, Leader, I had also recognized the member from St. Anne's Southeastern who had indicated if she wants to yield to you, that would be fine. Is she? Very well.
Testing. Yes. I thank the Leader of Opposition Business and the member for South East St. Anne for affording me the opportunity to say a few words on this topic of mandatory minimum sentencing. Generally speaking, the legal profession and the judiciary do not like the concept of mandatory minimum sentences. The reason being that, first of all, it removes from the adjudicator of the case, the judge in charge, the ability to do justice in the particular case before him or her in the court, which is the constitutional role of a judge in a criminal case. Now, there are some instances where the courts have actually ruled that, for example, the mandatory death penalty was unconstitutional. And that was what led, in part, to the amendments in the first decade of this millennium to change the way in which the death penalty was dealt with in our law. So whereas before, the penalty on conviction of murder was the capital penalty, death by hanging, that was changed so that it became a discretionary matter for the judge in respect of that category of murder that attracted the potential of the death penalty. So it was no longer mandatory, so-called capital murder. It was no longer mandatory death. It was discretionary. As I understand it, you are not proposing to change that, or to try to change that. Now, when I became Minister of Justice, there were on the books, the existing law related to murder was on the books then, which does have a mandatory minimum sentence attached, both a capital and non-capital, and you're proposing to increase that minimum here. There's also mandatory minimum sentencing for the offense of rape, if tried in the Supreme Court, and Circuit Court, and grievous sexual assault of 15 years, mandatory minimum. And I believe an attempt was made at one time to, and I'm not sure of the status of that now, but I suspect it, in the offense against the person at the shooting with intent offense was given a mandatory minimum of 15 years at one time.
I don't know if there's a mandatory minimum for those offenses.
For which one?
For rape and
so on. There is.
You're sure?
There is. For rape and grievous sexual assault, if tried in the Circuit Court. So I know what you said about the firearms offenses under the new firearms law, but there is actually a wrinkle in that, because there is discretion in the prosecution whether to charge under one of the offenses in Part 2. For example, the prohibited weapon possession offense, which does attract a minimum sentence, a mandatory minimum sentence, or to charge under Section 45 for having an unauthorized firearm. And if that is tried in the parish court, because the prosecutor can decide whether to bring those proceedings, those criminal proceedings, in the Circuit Court or in the parish court, if you're charged under Section 45. If brought in the parish court, then the potential for a fine exists, or for, I think, the sentence is capped at 5 years. And in fact, we had a recent case with a foreigner who was caught at the airport, I believe, with some ammunition. And that was the provision that was used, I believe, so that they got eventually, it was a relatively mild penalty was imposed. So it's not 100% accurate to say that under the new law there will necessarily be very stiff penalties. It depends on the prosecutor's approach to the case. And in my view, given the wide array of circumstances in which somebody may be found with a weapon or ammunition, it's not a bad thing that there are different avenues for prosecution that can take into account the severity of the situation. I, as Minister of Justice, never brought any legislation to Parliament that imposed new mandatory minimum sentences. I didn't do it because I don't believe in it, personally. I don't believe in it because I don't think it is consistent with the role of the judge, which is to be able to impose the sentence that fits the crime. We are, in a sense, arrogating to Parliament that by imposing in the law a minimum amount by which the judge can't go below. And I know that in many cases that may lead to a just result, but there will be cases where it does not. And those are the cases that bother me. Having said that, when those minimum sentences were imposed, I think around 2005 or thereabouts for murder, the murder rate in the country, I believe, was significantly lower than it is now. It was still way too high. I'm not sure about that. 4 or 5, I think. Yeah. I think that we need to, I personally would not object to the idea of raising the minimum for murder. And also the period for parole, because we need to make a statement to the society that murder comes with, if you commit murder, you're facing the most stiff possible penalty. And I wouldn't personally object if there was a sunset provision on this to see how it works over the next 2 or 3 years, because the basic approach is one which is removing from the judge the discretion over sentencing, which is really not the way we want to go. It may be necessary because of the extreme conditions in which we're living now, but one hopes that there will a better strategy towards managing national security issues, and as the efficiencies in the justice system improve, hopefully we'll have more accountability and people no longer be able to commit serious offenses with impunity, and therefore we will see an improved performance overall in the area of national security. Jamaica hopefully will become a safer society, and we can move away from the more extreme positions of taking away from the judiciary a significant portion of their discretion over sentencing. You know, it must be very disheartening for a judge to be faced with a situation where, in their opinion, the appropriate sentence in accordance with the sentencing guidelines, because remember, parliamentarians, that the judges have developed sentencing guidelines for the offenses that come before them. And those typically have a range with a minimum, but which they would not normally go below, and a maximum for each offense. So where a judge is faced with a situation where he or she really feels the appropriate sentence in the case before the court is 8 years or 12 years, and is told it has to be 20 years or 45 years, that must be problematic for them. And one hopes, especially as we have more cases being tried by a judge alone, we hope that the prospect of having to hand down a sentence which may appear to be manifestly excessive doesn't impact the way in which the evidence is assessed in the particular case, because they want to say, well, the threshold of reasonable doubt must be really rigorously imposed in order to find a conviction. So, in summary, Madam Speaker, we are living in extreme times, and it calls for firm measures. As long as the measures are not unconstitutional, I am not going to object to the measures. My own philosophy is one where I think mandatory minimum sentences are the wrong approach. The judicial discretion to do justice in the particular case ought to prevail. But Parliament has, for some time, in certain areas, been of the view that we have to have a floor in order that the society as a whole gets a sense of how their elected representatives feel about that particular issue. And I would not be objecting to what is proposed here. I just want to ask, though, there are some offenses which are particularly egregious and are contributing in a major way to the very extreme murder rate that we're living through. Gang-related offenses and scamming offenses, which often finance gang-related activities. Is there no thought being given to having mandatory minimum sentences in that area? Given the route that you're proposing to take, I would ask you that. Thank you, Madam Speaker.
First of all, Madam Speaker, let me just say that ever since I've been Minister of Justice, one of the areas which has really been of great concern is the look at all penalties across all classes of offenses. It's still an ongoing process, but I really hope it can be dealt with. In relation to gang-related offenses, scamming and so on, all of those have been looked at, but nothing has yet come to Parliament. May I just say that this is a preliminary position when the bill will come to Parliament, and we can even debate it more. Let me say though, member from St. Andrews Southwest. What is the judiciary frowns on is fixed penalties. To the best of my knowledge, they rarely frown on mandatory minimum. But I can tell you, I've read quite a number of cases where they may speak about the level of the mandatory minimum. But that is why, remember, the OAPA gave an option. For capital murder, it's death or life imprisonment. And the minimum time to serve for parole is 20 years. We are now proposing an increase in that. The 3(1)B, if it's non-capital, it's life imprisonment or a fixed term of 15 years. We're proposing to move it higher. Proposal is 45 years. The point, right. The point, Leader of the Opposition, is the country feels, believe me, you will listen, that a person who takes life, most of them believe it's the death penalty. And there are many who are clamoring. If you do a poll, believe me, I think 80 or 90% of them would favor the death penalty. It exists. It is possible. It is possible. It is possible in egregious cases for the Crown to seek the death penalty. So it's there. But, Leader of the Opposition, the feeling of many victims and the families of victims is that where a life has been taken, the offender really should get a long period in incarceration. You understand? When you listen to people, they just feel, okay, regardless, the person's taken life. They don't deserve to be out there enjoying their life. And it can't be after 10, 15 years, them back out there enjoying their life. The feeling is that after they take life, they are deserving of a long period of incarceration. So the bill which will come to Parliament will be reflecting this. So it is something that we all have to live with. The truth of the matter is that we are hoping that when we impose these, and as we have agreed, we are going to look at, in a bill. And it's possible that we can look at it either by public discussion or a joint select committee to look what is appropriate. The point, though, Leader of the Opposition, is if a judge thinks that the sentence is unduly harsh, the judge can send it to the Court of Appeal. You know this, under the Criminal Amendment Act. So he can send it, or if it's a good case, if I might say so, I hate to think of any murder case being a good case, that the prosecution and the defense and the judge could look at, we want to provide that in plea bargaining some more appropriate sentence could be imposed. Right. So we are looking at that possibility in the bill. So what we are doing, though, in this act, is that you have some heartless people. When I see some of the murders that they engage in and commit, you know, you wonder what to do with these people. And I mean your previous felt that some of these people are irredeemable. You know, those persons should really not be a part of society. So you put them in another part of society. So you will understand, and you are a former Minister of Justice and a Minister of Justice. I am prepared to strike a nice balance. Okay? So when the bill comes, we will look at it. Thank you, Madam Speaker.
Member, we have heard you loud and clear. We have heard you. Good. Just that we all, okay. The member from Centre and Southeastern had put her hand up, but I gather that the member from St. James, West Central, wants to raise a point of order. So right after, then, and then. Go ahead.
Madam Speaker, I would have taken the point of order at the time when the Leader of the Opposition was speaking, but I decided to just wait to hear what he has said. But I think it's important because he has said a number of things, and not all of which are correct, including that it is not consistent with the role of the judge to have mandatory minimum sentence. It's taking away from the judiciary portion of the discretion, and it's arrogating to the Parliament a minimum which the judge can't go. Madam Speaker, I think, especially with law students present, that accuracy matters. And recently, this issue of mandatory minimum, the role of the legislature, the role of the judiciary, was clarified as recent as June, July of 2022 in the Chandler No. 2 judgment of the Judicial Committee of the Privy Council. And I just invite your attention to the paragraph starting at 79 for the purpose of this point of order. It says that what has been recognized as constitutionally unacceptable is that a legislature should prescribe the penalty that is to be imposed on any particular individual. And cases are stated in support of that principle. It goes on to say that there is nothing inconsistent with the separation of powers in many constitutions on the Westminster model for the legislature to prescribe by legislation the penalty to be imposed for a particular offence. It speaks to Lord Millett in the case of Rodal, setting out, and another case, stating that there is a clear distinction between the prescription of a fixed penalty and the selection of a penalty for a particular case. The prescription of a fixed penalty is the statement of a general rule, which is one of the characteristics of legislation. This is wholly different from the selection of a penalty to be imposed in a particular case. The legislature does not prescribe the penalty to be imposed in an individual citizen's case. It states the general rule, and the application of that rule is for the courts. If the general rule is enunciated in the form of a fixed penalty, then all citizens convicted of the same offense must bear the same punishment. But if the rule is stated by reference to a range of penalties to be chosen according to the circumstances of the particular case, then a choice of penalty falls to be made, and that matter, at that point, the matter has passed from the legislative domain. Goes on to say that the board, in an opinion delivered by Lord Diplock, expressed a similar view in Hines and the Queen, a Jamaican appeal. Lord Diplock applied another case, words to constitutions on the Westminster model. In relation to the power which the Constitution vested in the judiciary, he stated, implicit in the very structure of a constitution on the Westminster model, that judicial power, however it be distributed from time to time between various courts, is to continue to be vested in persons appointed to hold judicial office in the manner on the terms laid down in the chapter dealing with the judicature, speaking of the Jamaican Act. And it says, turning to the role of the legislature, that is a parliament, in the exercise of its legislative power, Parliament may, if it thinks fit, prescribe a fixed punishment to be inflicted on all offenders found guilty of a defined offense, as, for example, capital punishment for the crime of murder. Or it may prescribe a range of punishments up to a maximum in severity, either with or, as is more common, without a minimum, leaving it to the court to which the individual is tried to determine what punishment, falling within the range prescribed by Parliament, is appropriate in the particular case. It also says, Madam Speaker, because I just find it unfortunate, this pitting of the branches of government against each other in comments. Hold on. The judgment of our final court says the separation of powers also works to prevent judges from arrogating to themselves powers vested in another branch. I just ask, Madam Speaker, that, not liking a particular approach doesn't make it wrong in law. It doesn't make it unconstitutional. And I think
take him back to law school and
Madam Speaker, the role assigned to the Ministry of Legal and Constitutional Affairs under the subject matter of legal education is becoming so difficult because people listen to the Parliament and they expect accurate statements to be made. And so much of what is being said about what is supposedly constitutional and what isn't. Madam Speaker, we have good guidance from the court on those matters. It's not just a matter of what we believe or what we say so. So just to be clear, Madam Speaker, it is the role of the Parliament to prescribe penalties for offences, and there is nothing unconstitutional about it, be they mandatory minimum, fixed penalty, or otherwise.
Madam Speaker, the minister was charging along at a sandcastle which I hadn't built. I did, and she and her colleagues, the minister and her colleagues, may have been pleased that that sandcastle was hit, but that wasn't my sandcastle. The point.
Members, just a moment. Members, it is the start of 2023. There are students from the University of the West Indies, and they are learning, and we want them to learn the right things by the right methods. And we want them to understand that every member of Parliament in this House has a right to be heard. Please, come.
Thank you, Madam Speaker. Member, yes, you know about my pay grade, apparently. Madam Speaker, I never said that a mandatory minimum sentence is unconstitutional. I said that in the case of murder, the mandatory capital offense had been ruled unconstitutional, and then our law was amended to accommodate that. When Lord Diplock was speaking in Hinds and the Queen, in the passage that the minister read, where he said that Parliament may impose a mandatory death penalty for murder, that was a law at the time, but that was subsequently moved away from by the same Privy Council. I think the case was called Lambert-Watson, but I'm not 100% sure. But they made a ruling in relation to murder. That is why we do not have any longer a mandatory death penalty for capital murder. Apart from that, I'm not aware of a situation in which a court has said that a mandatory minimum sentence is unconstitutional. Depending on how extreme that minimum is, the possibility does arise that it could be tested. But my own view is that the separation of powers ought to be respected, and the role of sentencing and doing justice in the individual case is quintessentially a matter for the judge, which is why, in my view, I do not like mandatory minimum sentences. And I said that in my... And when I was Minister of Justice, and when I was Minister of Justice, I never brought any legislation to Parliament which had mandatory minimum sentences in it. But I said at that time, mandatory minimum sentences did exist, which predated me being minister, for murder. Both capital and non-capital have mandatory, for rape, for grievous sexual assault, and I was questioning whether also shooting with intent, which I think an amendment had been made when the time when those bail acts were passed. One of the 5 bills made an adjustment to put a 15-year mandatory minimum sentence for shooting with intent. I do not recall whether or not that continues in the law or not. So the point is, yes, the judges and the Privy Council and others have said it's within the parliamentary discretion to impose minimum sentences. But my point is, I do not like them because I think they offend against the principle that a judge's role is to do justice in the particular case. And if you take away the discretion of the judge by putting a minimum, then if in the judge's view the sentence ought to be less, the judge cannot impose that lesser sentence. That's what I was saying. And I also said that in the extreme situation in which Jamaica finds itself today, I would not be opposing the increases in the minimum that the minister has advocated for in his statement. So I'm not sure why the pretense that this is an issue about constitutionality. That was never put on the table by me in my presentation today.
Members of Parliament. The member now from Southeast Centre.
Madam Speaker. No. I just need them to read. I can see the speaker. Madam Speaker, I think one of the mistakes that we sometimes make as parliamentarians, and even though why we're here is to develop legislation, I think there are 9 lawyers over there and there are 4 over here. The rest of us, and all of us, I would imagine, have to deal with everyday problems with Jamaicans. The truth is, all of us in here are subject to the daily reports of the heinous crimes that are being committed. Just today I read of an elderly lady whose house was firebombed. She was 87. The fact that we have persons in this country who are adept and conscious of slashing 5 people's throats or murdering a young woman and then going back to his mechanic job says that there is something that is really, really wrong. But no one was born a criminal. Something went wrong, and it went unchecked. And the truth is, if you look back at the data from 2011, Professor Hicklin said that, look, 41% of our population suffers from personality disorder. Dr. Herbert Gale says that 53% of all murders committed in this country are committed by repeat killers. So obviously, and the question I have, because they're predisposed to it. So the adverse environmental conditions that all of us, successive administrations, as members of parliament, I would be in here going on 4 terms. Some are in here 1 term. We know the water problems, we know the poverty problems, we know what our children are going through. A child isn't born a murderer. And right now, in 2020, back then, 18% of our population between the ages of 15 to 34 committed 75% of our murders. So the question I really have for the minister is, all of us can agree to continue to bludgeon people into fear in this country. I've sat in here and I've watched us amend legislation to put rapists behind bars for longer periods, sexual assault on children. It has not moved the needle. It hasn't. And I don't suspect that based on what is happening with our population and how heinous our criminals are, that putting a mandatory sentence, but we will debate that bill. The question I have is that we always come here, Madam Speaker, we talk about bludgeoning people into acquiescence. I listened to the Minister of Finance yesterday as he deliberated our colonial past. And the fact is there are good people, and really bad people. That's what you said. Well, very bad people is what you said. And the fact is that because of our colonial past, we nationalize a lot of the infractions. Now, he was thinking on the fly, but I understood the profound statement you were trying to make. The Prime Minister put in place some time ago a commission headed by Dr. Herbert Gale and Dr. Marlene Samsvaughan. There's a representative of the opposition that sits on that. When minister, we come here all the time. I get up in this parliament ad nauseum to ask what is the corollary approach that we're going to take. Because if 53% of the murders are being committed by repeat killers, and most of the murders are taking place by young men, what are we putting in place in this society to address those adverse environmental conditions that are creating the personality disorder? Because we can continue to do this, and where is the information and the report from the commission that I believe the Prime Minister had put in place from about 1.5 years ago?
Madam Speaker, I want to thank the member from Southeast St. Anne. Obviously, I don't have an answer. Truth of the matter is there's no utopian society. There are many societies where the murder rate has dropped significantly or very low, and we can look at them. But anyone who has studied criminology, Madam Speaker, will know that there's a variety of reasons why people engage in crime or commit murder. But until we can find and remove many of the negatives within the society, we can't throw our hands up in the air and say, wait until they are dealt with. The society has to respond, as we're trying to do now, with the level of murders and criminality across the country. So I will agree with you that clearly you need more jobs. Clearly you need better roads and water. Clearly you need people to feel a sense of hope. But at the same time, in responding to what is a crisis of violence, and it has been going on for 20-odd years, or more than that, we simply must now deal with some of these persons, you understand, who really, as you quite rightly say, many of them are committing multiple murders. You would need many of them incarcerated for long periods. So I agree with you, and I agree with the member from Eastern Kingston. We have to find them. We have to apprehend them. But once you apprehend them, put them away for a long time so there's no possibility of them doing the 2 and 3 crimes. So I don't have a correct answer for you, But the truth of the matter is we can't throw our hands up in the air. We really have to do it at several angles.
Bobby, why you cut off my mic? Madam Speaker, I'm not asking for a silver bullet answer. However, when the minister says that we're going to put them away for a long time, you have a generation coming behind. So is it that we're going to be putting generations of people behind bars, Minister? And the reason I know it is a very broad question to ask, but based on what the minister has said, what I would like, Madam Speaker, I saw where the Prime Minister spoke about mental health earlier this year. Perhaps it might be the tipping point at this point in our parliamentary life, as a whole parliament, not a joint select parliament, as an entire parliament, to have a real discussion around the contributors of crime and to take some solutions, because that money that you're going to take to build those prisons, or that big prison that you're going to be putting people away in St. James and different places, perhaps we can utilize a better way to harness other funds that does the other generation coming forward. So, Madam Speaker, I hear the minister, I understand what he's saying, but I put to you, and maybe you can put to the Prime Minister, that it is time that we have an honest approach about what we really need to be doing about interrupting those contributors that is creating these heinous murderers that are in this country.
St. Andrew. Thank you very much, Madam Speaker. Madam Speaker, I'm not going to repeat some of the arguments that have already been made, except that there are a couple of things that trouble me in the statement by the minister. And because it is so easy for others to misunderstand, I want to stand very, very squarely to say, like others here and outside, I am well aware of where we are in terms of murders and the kind of heinous acts that we see. I am as repulsed as the next person. I understand the level of fear that individuals have in the community in terms of where we are. And therefore, I am in total agreement that we need to look at maybe some drastic action that could lead to a reduction and a turnaround in terms of where we are. But what bothers me is that along with the discussion that we're having, I believe that there has to be, and I think the member from South St. Andrew said that there has to be a companion piece that allows us to see very, very clearly how the pieces come together in terms of solving the problem. Because it is... I'm sorry, no, Minister, I'm on the... Minister, please. Madam Speaker. We want to see it, I said that, we want to see it hand in hand so that we can make the connection of how they go together as a whole to reduce and to change where we are. One is around the mental state of many of our people. The other for me, though, and it struck me while the minister was speaking, we come here sometimes and many of us have this notion that there are some communities where people don't speak, and they don't speak because they see these gangsters as saviors, and that is the reason why they don't provide the evidence and all of that. And every time it is said, I say to myself, there goes an upper St. Andrew person. Someone who doesn't quite understand what takes place in some other communities and why persons take the position they do. I don't think I have to remind you, Minister, because I believe it must have been at least 2 ministers that I have heard make the statement that they have given information to the police. And before they get back home, the criminals themselves could call and say that the information had been given. So what that means is, at the very least, there's a huge hole that we need to plug about what is, and you said it, what is the channel? What is the appropriate channel? Because in some cases, the police, the JCF may not be the appropriate channel, when one would have thought that that is the most logical channel. But it is flawed there. So that is one issue. Then, in terms of that chain of people who we are breeding who are part of the problem, one is around persons and what we're doing in terms of their mental state and ensuring we can identify those with problems from early and change those around. But it's also the conditions in certain communities where, honestly, the state has long been unable to convince persons who live there that they can actually protect them. I want, when we come here to make these statements and to talk about what we are going to do, that we understand that that is a real problem that we have to deal with, a real problem that we have to deal with. And then the other thing is, I believe too, there is a sense almost of them and us in the society. And so when we come to deal with issues like these, I believe we also have to look at what others might see as the kind of white-collar crime that people normally get away with, and we don't pay much mind in terms of the penalties and what we do to catch them and make sure that that too is under control. We go in other jurisdictions, I hear them saying, to really get rid of the problem, you really go to those who are at the top of the food chain, who are responsible for what is happening. You don't go to the bottom and pull those, yes, who are least powerful, have the lowest voice, yes, and are not able to defend themselves in the same way. Because, yes, you might tick some boxes about the number of persons that you have incarcerated, but you have not made a dent into the problem. Because, as the minister keeps telling, well, as the JCF and others keep telling us, is about 300 people that you're really looking for, that if you could make a dent into that, we would make a dent into the question of crime. If that is so, we have to carry along with it the actions that are going to really lead to that. I'm not sure, Minister, if you have the evidence or the research that tells us that stiffer penalties, yes, deter criminals. I haven't read it, and without more. I haven't seen it. Granted, my research has been cursory, yes, but I'd love for you to present that evidence when you come back with the bill, so we can make the connection between stiffer penalties and what we are hoping to achieve, because I believe that it is absolutely important. And then just the last thing, I spoke about just white-collar crime, but Minister, I'm not sure if you understand that people believe that corruption is as bad as anything else that we have to deal with. And that too many of us sit quietly and allow the system to flow so that those who are responsible for these acts of corruption skate free. And they have a lot of arguments out there about why we do it. Yeah? I am just saying that, especially because, as you have recognized, how bad this issue is and how important it is for us to arrest it, that issues like corruption be given the same kind of treatment, that we come here with the same kind of venom, the same kind of passion, to make sure we make also some stiffer penalties, yes, so that those who are responsible for these corrupt acts will not go free.
Thank you very much, Madam Speaker. I believe Angela's, okay, the member from Southwest St. Andrew has said some of the things that I would wanted to express. That's not your prerogative, member. But just to add, Madam, from Denham Town? He's from Denham Town? I don't know. Madam Speaker, I would like to ask the minister if there is any comparison in terms of have you used the data or you have any scientific proof in terms of hanging? Because hanging is the extreme case. Have you used it to measure whether or not it had ever decreased murder, especially crime, especially that is to whether or not it is you have ever used that instrument to use it to determine whether or not it has ever beared any fruit in terms of making crime less. The other question I would like to ask, Madam Speaker, is that over and over, we have some very simple solution that can prevent crime. And I've never heard anyone in this parliament try to make sure that it is put in place. And it is to find the root causes, to do the things that can prevent crime. We try our best when it comes to this crisis because we are good at dealing with crisis. But to make sure that we have civil societies, civil communities, nothing has been put in place, some basic things. Some people better off going to jail than staying at home because they have no home. We don't look at housing problem, we do not even look at education. No. And I am very parochial, you know. So we are going to go very parochial. The things to prevent crime, we never touch it in this country. It is very, very easy to let that go on, just go unnoticed until it becomes crisis. I believe any debate in here must take in consideration some of the reasons why these crimes is being committed. And I am not going to be a part of anything that we don't look at preventative measures, but we look at making more time, believing that it can prevent crime.
Madam Speaker, I think we can wrap up. I just want to. He has yielded. Madam Speaker, my statement today and the bill that will come hopefully within the next week or two is not to say that the increased penalty for murder is the solution. Believe me, I don't think increased penalty or harsh penalty is a solution to crime. But it is something that the state requires. Right. The truth of the matter is that is why I quoted Lord Denning so well. Harsh punishment. Good man. My friend, you know. Madam Speaker, the truth of the matter is that, as he quite rightly said, a harsh penalty is not necessarily for deterrence, reformation, and what have you. It is for society to say to the rest of the country, we denounce that form of behavior. And in other words, all wrongdoers must realize that there are consequences to their wrongdoing. So, Madam Speaker, in closing, I do appreciate the members. We have problems. And all of them need to be addressed. There are other agencies that are addressing some of them. A penalty, a harsh penalty, be it hanging or any harsh penalty, is not the utopic solution. It contributes, it is needed, because victims in particular feel a sense, and police officers, where they have worked hard to apprehend someone, and the man gets a suspended sentence, and when it's murder, he gets a suspended. They feel they're wasting their time. So it's very important that in matters like murder, we impose an appropriate penalty, which is a long term of incarceration. Thank you, Madam Speaker.
Very well. House Leader.
Thank you, Madam Speaker. Madam Speaker, we will now have a statement from the Honourable Marlene Malahoo Forte, Minister of Legal and Constitutional Affairs.
Minister,
thank you, Madam Speaker.
And member from St. James, West Central.
Madam Speaker, this ministerial statement is intended to further update this Honourable House and the people of Jamaica on the status of the Constitutional Reform Committee, as well as to publicly set the record straight on the written and verbal exchanges between the Leader of the Opposition, the member from St. Andrew South, and me on the matter. Madam Speaker, I confess that I'm experiencing mixed emotion because there has to be a proper place reserved for private communication as we set about doing the work assigned to us. But, Madam Speaker, you may recall that when I spoke here in this Honourable House last week, I expressed deep disappointment at the stance that the Leader of the Opposition had taken to decline the government's invitation to participate in and name members of the parliamentary opposition to the Constitutional Reform Committee until his queries were answered in the way that he desired, among other things. Madam Speaker, later that said day of Tuesday, January 11, 2023, the Leader of the Opposition's PNP issued a media release under the caption, "Series of Correspondence between Mark Golding, MP, and Marlene Malahoo Forte, KC, MP. Attached to that release were 4 pieces of correspondence between the Leader of the Opposition and me regarding the proposed establishment of the Constitutional Reform Committee. Madam Speaker, the media release expressly stated that the series of correspondence began with a letter from Mark Golding to me on June 3, 2022, with a follow-up on June 22, 2022, my response some 7 months after, on January 5, 2023, and finally his response on January 10, 2023. Madam Speaker, the statement is plainly false. He did not begin the series of correspondence, and I should say that I did not receive any follow-up letter on June 2022. If he sent it, I didn't receive it, and I checked at my office and they said it was not received. But that aside, Madam Speaker, just to set the record straight, the correspondence between the Leader of the Opposition and me on this matter began with my letter to him of May 31, 2022. It followed with my speaking to him within a matter of days, answering his queries and explaining to him that my sectoral presentation would have contained additional details. Those details were provided orally when I spoke in his presence and on June 7, and they were also set out in the printed presentation of even date that was distributed. Madam Speaker, the Leader of the Opposition should recall that I even made specific reference in my letter to him in the sectoral presentation. and I provided specific answer as best as I could at the time to his question concerning the need to revisit the Charter of Fundamental Rights and Freedom so soon. Madam Speaker, I wish to direct the Leader of the Opposition's attention to the section of the printed presentation, and in case he doesn't have a copy, I have brought another copy for him, under the heading Constitutional Reform, which begins on page 22 at paragraph 55, and I should like to draw his attention specifically to paragraphs 87, 88 through to the end. And at paragraph 94 on page 29, I provided him an answer then, as best as I could, on why review the Charter so soon. Madam Speaker, I should also like to share, as part of the record, my responses to the Leader of Opposition's concerns expressed in his letter to me, dated January 10, 2023. With respect to the first concern, which indicated that the move to make Jamaica a republic ought to walk in tandem with the move to accede to the CCJ as our final court of appeal. My response was, as stated in the January 16, 2023 letter, a change of Jamaica's final court is not one which requires a referendum to effect. At this time, there is no consensus on making the Caribbean Court of Justice, CCJ, our final appellate court. Since the constitutional reform work is being done in phases, beginning with the matters requiring a referendum and on which there is consensus in phase 1, it would be unwise to further delay the work now when ample opportunity will be provided with the assistance of the Constitutional Reform Committee to fully ventilate this issue at a later stage. In respect of the second concern, the Leader of the Opposition requested full and transparent disclosure of the specific changes to the Charter of rights that the government is intent to pursue and of the amendments requiring a referendum that the government intends to pursue other than moving to a republic. Madam Speaker, again I responded by making it clear that, as I had repeatedly said before, we're not starting from scratch with these reforms. Instead, we're building on the work done by the Joint Select Committee on Constitutional and Electoral Reform and the Constitutional Commission, culminating in the recommendations set out in the 1995 report to the Parliament, on which consensus was reached. Madam Speaker, we have made it clear that every change to be pursued will be fully disclosed and collaboratively worked on with the assistance of the Constitutional Reform Committee, guided by research, consultation, and expert advice. Phase 2 of the work will focus on the ordinarily entrenched provisions of the Constitution, which include the Charter and also the matter of our final court. Madam Speaker, I indicated that it is no secret that the government has signalled its intention to revisit, for example, Section 20 of the Constitution to provide an up-to-date emergency powers framework, given the experience of the nation with the COVID-19 pandemic and the government's effort to secure our borders and people in the fight against organized and violent crimes of epidemic proportions. Furthermore, Madam Speaker, and among other things, the language used in various provisions of the Charter, including at sections 13 and 14, requires some tidying up. Section 12, for example, requires modification as the current 6-week time frame set out in it was not revised when Section 20 was amended with the passing of the Charter. Madam Speaker, by way of another example, Section 2, which is the section that provides for constitutional supremacy, will have to be modified in light of the repeal of Section 50 when the Charter was enacted, And that will involve a referendum by virtue of Section 49(3) of the Constitution. You know, Madam Speaker, I recall so very clearly, in one of my verbal exchanges with the Leader of the Opposition, I mentioned the requirement for a referendum to modify Section 2 to reflect the changes made in the Charter. And the Leader responded, the Leader of the Opposition responded, "That gone through already." And I pointed out to him that unfortunately, I could not take that approach as the provisions of the Constitution were clear about the correct approach to be taken. No, you see, Madam Speaker, the response and the exchanges were minimized, as if nothing was said. But, Madam Speaker, I also wish to report to the Honourable House and the people that I shared the draft terms of reference that will guide the work of the Constitutional Reform Committee with the Leader of the Opposition. It was attached to my letter dated January 16. And, Madam Speaker, it's really my hope that the Leader of the Opposition will reconsider his position to twin accession to the appellate jurisdiction of the CCJ with abolition of the constitutional monarchy and the transition to a republic. It is our view that naming members of the parliamentary opposition to the Constitutional Reform Committee is the right and responsible thing to do. Madam Speaker, working collaboratively to strengthen and build consensus will be a powerful demonstration to the people of Jamaica that government and opposition can rise above partisan considerations and put the best interest of the nation in a place of priority during this constitutional reform process. Madam Speaker, I've also made it clear that if it comes down to it, we would be prepared to proceed in accordance with Section 49(5) and 49(6) of the Constitution. But, Madam Speaker, at the same time, because we consider the participation of the parliamentary opposition to be vitally important, we're allowing further time for reconsideration by the Leader of the Opposition. I signaled to him in my letter my willingness to meet with him if necessary, but I have not heard back from him since then. Madam Speaker, we are working with ambitious indicative timelines, which already will have to be revised in light of the delay, to effect the reforms. I really hope that we will not be forced to proceed without the Leader of the Opposition nominating his members of the committee. It is our intention for the tenure of the committee to commence in this month of January and run to 2024, next year, when a referendum is likely to be held. And, Madam Speaker, you know, as I've said before, the work will be done in 3 phases. Phase 1, we hope to deal with repatriation of the Constitution, abolition of the constitutional monarchy, establishment of the Republic of Jamaica, and all matters within the deeply entrenched provisions of the Constitution, for which a referendum is required to amend. And the second stage will be the knotty stage, when we will review the matters of particular interest to the parliamentary opposition, but just to say that they are of no less interest to us on this side. And then we will wrap up with a full assessment at the end of the day, promulgating a new constitution passed by the Parliament of Jamaica, reflecting the determination of the people. Madam Speaker, it is ambitious, but most of the work has been done. You know, this is not work we're starting from scratch, and we are taking advantage of what has been done before and on which consensus remains. So I close, Madam Speaker, by saying to the Leader of the Opposition that I hope that he will reconsider his position, that he will name his members to the committee, and that he can be assured that the issues of concern will be answered frankly and fully, but bear in mind it is work in progress, and that the purpose of the committee is to assist in building consensus where none exists, where it has eroded, or where it needs to, among other things. Madam Speaker, that is the update for this Honourable House at this time.
Thank you, Madam Speaker. Madam Speaker, the letter which I wrote to the Minister at the beginning of June was expressly responding to her letter of, I think, May 31st, in which she had invited the opposition to name 2 members to the committee that she proposes to establish. I wrote at the beginning of June setting out some concerns about the approach that was being taken. I didn't get a response. These were serious issues which I wanted a formal response to, and I still do. I sent a follow-up letter 3 or so weeks later because I hadn't had a response. Now, I'm hearing from the minister now for the first time she didn't get the follow-up letter. Anyway, she hasn't denied getting the substantive letter which was sent at the beginning of June. We have had what I regard as casual and informal, brief discussions in here on some of those issues. That is not a considered formal response of the government to the substantive issues raised by me as leader of the opposition in a formal letter to the minister. And I did not get that response for 7 months until well into January. When I replied to that response in January, the minister came here and berated me in no uncertain terms. And I felt, and I still feel, that it was necessary to bring to the attention of the country how that correspondence had unfolded and the disrespect with which I had been treated by her. Anyway, in her latest letter to me, which was received last Thursday evening when I was out of town, the minister went through another tirade before moving to the issues that I have asked her to provide full disclosure of. And I just want to read one sentence that the minister put in her letter to me. She says to me, "Should you persist in your refusal or delay, you will force me to invite interested parliamentarians from your side to come on board." Now I tell you, I don't know how you want to embark on a process, a collaborative process, making remarks like that. I think totally inappropriate. Totally inappropriate. Madam Speaker, just for the record, I have written to the minister today. That letter is at her office. It's on her email. It is. I sent it before I came here. And my assistant emailed it to her and copied me. I received it. There are 3 issues. The first issue is the minister says there is no consensus at this time for moving ahead with full decolonization, becoming a republic rather than having the British monarch as a head of state, and moving to the CCJ, the Caribbean Court of Justice, established by Caribbean nations with the intention to be the final court, rather than Her Majesty's Privy Council, the Judicial Committee, sits in London, established in the 1830s, a colonial construct. I have said, you've said that there's no consensus to move with that at this time, and you want to take it in phases and deal with that after. And I've said to you, well, there's no consensus on our side for moving ahead in that piecemeal way. We want to move to full decolonization now. And no good reason has been put forward for delaying it. So I have not said we won't appoint members to the committee. In fact, my letter to the minister says if she responds to me and gives me the disclosure that I've asked for, reasonably asked for, I will appoint my members, the opposition members, forthwith. But there are some issues which I need to have clarity on before we embark on the process. Because when you talk about amending the Charter of Rights, and what the minister said is that we want to modernize the framework, I've asked her, what does that mean? What are the specific changes to the Charter of Rights that the government intends to pursue? The minister has been working on this for a year. The minister well knows what it is that they would like to see changed in the Charter. I'm saying, please make disclosure to us so that we can determine whether those things are acceptable or whether they require prior discussion. Now, the truth of the matter is, You cannot amend the Charter of Rights without both the government and the opposition being on board. So if you're interested in collaboration, just give me a respectful response to my request and give me the information that we need. The other question I've asked her is, because in her correspondence she mentions a referendum to deal with the monarchy and other matters, and I've said, what other matters are those that you would want to deal with in the referendum? The reason being that a constitutional referendum is only required to change deeply entrenched provisions, of which the monarchy is one. I would like to know which others the minister has in mind. In her letter to me, she has said, oh, Section 2 needs to be amended because of what happened when Section 50 was repealed. She hasn't said what that amendment is. I suppose she would need to go and research it, but why not just tell me what you have in mind? And are there any other deeply entrenched provisions that you wish to amend? Let us stop this public cascas. I didn't come here to make this statement. I wrote you a letter today, and you come here for the second time in 2 weeks to berate me because I've asked you for full disclosure on what the government's intention is in relation to amending the Charter of Rights and what the government's intention is in relation to amending the Constitution when it comes to deeply entrenched provisions that require a referendum. I want to know that in advance. I think it's fair and reasonable because I don't want to go into a process where I am going to be somehow, we are going to be co-opted into a situation where we're going down a road which we have fundamental disagreement. I am hoping that is not the case. But as you know, Madam Speaker and members, the issue of the state of emergency regime is a very sensitive regime for us. For us on this side, clearly not for you, but for us it is. And, you know, when you talk about modernizing the framework, I want to know what you consider that, what does that look like? I'm not asking you to draft the provisions, but I'd like to know the direction in fairly specific terms that you want to go in relation to any amendments to the Charter. So I've written to the minister, and I've asked her please to let me have that information by the end of the week so that we can then respond and hopefully appoint our committee members, which we're ready and willing to do, and I would like to do without wasting further time. And I hope we can take this discourse out of the public domain at this point. But I would ask her not to treat me with such disrespect when it comes to these issues, because it's not necessary and it's not helpful. Thank you, Madam Speaker.
Madam Speaker, the Leader of the Opposition and I are agreed that we should continue the exchange outside of this medium. But when inaccurate statements are made, it's important to correct them when they are made publicly. I know some would say one side should be allowed to make inaccurate statements publicly, and when the other side responds, something is wrong. First of all, before I even proceed, Madam Speaker, may I just ask, both sides. First of all, Madam Speaker, let me just say to the Leader of the Opposition, it was never my intention to berate you. And if you felt berated, please accept my apology. That was not my intention. Hold on. Would you then consider that it's unfortunate that even in your response to me, you didn't even give a reason why an inaccurate release was made, that the correspondence began with your letter to me? I just say that little details matter, you know, because you can't brush over the things and then give the impression that one is being petty, because it casts a different light on the matter. No, Madam Speaker, the Leader of the Opposition is not a layman. It's not a layman. And perhaps it is my belief that some things can be said to him that would not require deep explanation, whereas they may be required for other persons. At no time did I intend the exchanges I had with him to substitute for a formal response. But what is clear is that the information provided to him in those exchanges answered the queries. May not have answered in the form that he liked, but it cannot truthfully be said that they did not answer. It may not have satisfied him, But whether it had come in writing at the time or it was given verbally, it would have been the same thing. And the additional details were provided. We're talking about 31st of May, June 7. That's a matter of a week. That's a matter of a week. But Madam Speaker, just to say, the impression is being given, and it is my hope that this clearing of the air will really clear it and we go forward. So when I say, for example, that Section 2 requires a referendum to change, it is because Section 2 is listed at Section 49 as one of the deeply entrenched provisions. And in Section 2 it says, subject to the provisions of Section 49 and 50 of this Constitution, if any other law is inconsistent with the Constitution, this Constitution shall prevail, and the other law shall, to the extent of the inconsistency, be void. Now, if you repeal Section 50, you would have to amend Section 2 to take the reference to Section 50 out of it. But the Constitution itself says, before you can touch Section 2 at all, you have to do it via a referendum process. I didn't say that. And that is an example of another matter that would be addressed with a referendum. So it's either we put back Section 50, which happens to be a parliamentary supremacy clause, or we put Section 2 to the referendum to properly change it and reflect the changes that the Charter of Fundamental Rights and Freedom intended. That's another example that I gave him. The other matter is that the wording of Section 49 is so cumbersome, Madam Speaker. But Section 49 itself is deeply entrenched, and one of the recommendations was to simplify the language. That's one of the recommendations set out in the report. Leader of the Opposition, it's clear to me that we need to speak. All right? Right. But I can't put it any higher than I have put it at this stage. What? About what? It's one of the recommendations. Madam Speaker, I reference that we will deal with the matters from the recommendations on which there is consensus. So you can't split hairs to say, I didn't specify 49 when 49 is a recommendation matter. Section 2 wasn't. Madam Speaker, just to say that accuracy matters. The Leader of the Opposition can be assured. I know his stance, because his stance is that if he don't design the process, if he don't like it, something wrong with it. No, he has said that. He has said that. I heard it with my own two ears Speaker, in another forum.
On a point of order, I have never said that I must design the process. I've simply asked for disclosure as to the amendments to the Charter that the government is intent to pursue, because those affect the fundamental rights and freedoms of the Jamaican people. And I'd like to know where the government wants to take that. And the other thing is that I wanted to disclose as to which deeply entrenched provisions the government is intending to amend. Now, if they're purely issues of tidying up, all the minister has to tell me is they're purely issues of tidying up. But if they're substantive things, I'd like to know what those are before we start in terms of where they want to go. And that's all I'm asking for. And I hope I can get it by Friday so that I can appoint the members of the committee.
Speaker, there are 1, 2, 3, 4, 5, 6, 7, 8 deeply entrenched provisions set out at Section 49.3, insofar as it alters this section, which is Section 49 itself, Section 2, Section 34, Section 35, 36, 39, subsection 2 of Section 63, subsection 2, 3, or 5 of 64, Section 65, or subsection 1 of Section 68 of the Constitution. Those are the deeply entrenched provisions. So, Madam Speaker,
hold on.
the leader said he wrote to me.
I really do think that this conversation must be carried on between official correspondence between both parties at this point.
Madam Speaker, the leader said he has sent the letter. He can be assured that I will respond. Yes. Yes. Why are you so contentious? So contentious. Why are you so contentious?
Announcements.
Thank you, Madam Speaker.
Laid on the table of the House today are copies of 1. Office of the Contractor General's 2017 Special Report of Investigation conducted into the allegations of conflict of interest, irregularity and/or impropriety in relation to the construction of buildings by Mr. Ian Hills, former Member of Parliament for Western Hanover, without permission from the Hanover Parish Council. Ministry Paper number 2 to 6 of 2023, entitled Annual Report of the SCJ Holding Limited for the years March 31, 2013 to March 31, 2017. Ministry Paper number 7 to 10 of 2023, entitled Cabinet Agenda Issues, dated September 5, 12, 9, and 16 of respectively of 2022. Ministry Paper number 11 to 14 of 2023, entitled Cabinet Agenda Issues, dated October 3, 10, 24, and 31 of 2022, respectively. Ministry Paper number 15 to 18 of 2023, entitled Cabinet Agenda Issues, dated November 7, 14, 21, and 28, 2022, respectively. Ministry Paper number 19 of 2023, entitled Cabinet Agenda Issues, dated 5th December 2022. And the Auditor General's Department Certified Appropriation Account, Head 15,000B for Office of the Prime Minister for the year 2015-2016, and Head 26,000 for the Ministry of National Security for the year 2018-2019.
Bills brought from the Senate, petitions, papers, reports from committees, notices of motions given orally. Notices of motions given orally.
Madam Speaker, I beg to give notice that at the next meeting of the House, I will move to introduce and have read a first time a bill shortly entitled the Road Traffic Reprieve and Nullification of Prescribed Notices Act 2023. Madam Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take first reading of the bill.
Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to sittings of the House. Motions for leave to introduce bills. Presentation of bills without leave of the House first obtained.
Madam Speaker, I now move for the suspension of the standing orders to enable me to take the first reading of a bill shortly entitled the Road Traffic Reprieve and Nullification of Prescribed Notices Act 2023.
Members, the question before the House is that the standing orders be suspended to allow the Minister to take the first reading of the bill. Those in favour? Aye. Those against? The ayes have it. Minister.
Madam Speaker, I now move that a bill shortly entitled the Road Traffic Reprieve and Nullification of Prescribed Notices Act 2023 be read a first time.
A bill shortly entitled the Road Traffic Reprieve and Nullification of Prescribed Notices Act 2023 read a first time.
Madam Speaker, I beg to give notice of second reading of the bill.
Members, I just crave your indulgence for a few minutes for the House leaders to discuss an important matter in relation to the city. Members, we're now at public business on our agenda. Public business.
Madam Speaker, it is not contemplated for us to do any further business today. I therefore ask that the House adjourns until Thursday, January 26th, when we will meet at 2 p.m. sharp.
Members, the question before the House is that we do adjourn until Thursday of this week, the 26th of January. Those in favour? Those against? The ayes have it. This House is now adjourned until the 26th of January.